Mr. Phipp.
My Lord, before I return to my submissions, this morning my Lord Carnworth asked me about the evidence before the Court of Justice on the practice in other member states. I have two references for you. The first is to the United Kingdom's observations in this case, which is Core Volume 2, tab 13, page 763 at paragraph 71, which is the information that was summarised for the Court of Justice.
Page 763.
763, my Lord, yes.
You're 13 on member states.
Paragraph?
71, top of the page, my Lord. The same information was summarised by Mr. Justice Henderson in his judgment. If you would like the reference for that, I'll give you that as well. That is Authorities, Volume 9, tab 77, paragraph 280, which is MS 3082.
Thank you.
Yes, that's right.
Yeah,
that's right.
Yes.
Okay, I remembered 13 member states.
Yes. My Lord, I'll return, if I may, to the submissions on issue 2. The next point I wish to make is that the other ways of interpreting the effect of the Court of Justice's judgment, that is to say, the ways taken by the courts below, do not make sense either of the court's reliance on effectiveness and equivalence or of the references at paragraph 29 to adequate, or at paragraph 30, the references to the specific matters and the reference to the need for a national court to have regard to all the circumstances of the case. Both the courts below reached the conclusion that the consequence of the Court of Justice's judgment was that the obligation to pay interest meant, for all practical purposes, a fixed requirement to pay an amount equivalent to the use value of the sums overpaid. And if I can go first to the judgment of the Court of Appeal, which is in volume 9 of the Authorities at tab 78. My Lord, the Court of Appeal addresses this point at paragraph 94, which is page 3165, or rather this is the focus.
3165?
Yes, paragraph 94 is the focus of the court's reasoning. And paragraph 94, and then after that the first part of paragraph 96, one sees from both those paragraphs that for the Court of Appeal, paragraph 25 of the Court of Justice's judgment was the linchpin, and in particular the description in that paragraph of the obligation as being one of reimbursement. So that was the premise for the Court of Appeal's conclusion in this case. In my submission, the reasoning of the Court of Appeal is problematic, precisely because it does not fit particularly well with paragraphs 27 and 28 of the Court of Justice's judgment and the role that the principles of effectiveness and equivalence have in relation to the content of the EU law interest obligation. And secondly, because by focusing on the notion of reimbursement at paragraph 25, the Court of Appeal fails, as I submitted earlier, to make sense of the judgment as a whole, and in particular, those references at paragraph 29 of the judgment and paragraph 30 of the judgment that I've taken you to on a number of occasions. Now, the Court of Appeal sought to address those difficulties at paragraph 108 of its judgment.
Thank you.
And that is page 3168. And it did so, and one sees from that paragraph, the court says this: we would emphasise the conclusions we have reached are those which apply in the circumstances of this case. As we have endeavoured to emphasise, adequate indemnity is not a rigid straitjacket and certainly does not go so far as to require compound interest in every case. Nevertheless, in the circumstances of this particular case, and having regard to the extent of Littlewoods' claim, we hold that section 78 deprives Littlewoods of an adequate indemnity for the loss occasioned through undue payment of VAT. So following there, those words within paragraph 29 of the judgment. In my submission, that reconciliation is not satisfactory because the court does not address what the Court of Justice has said at paragraph 30 of its judgment. if the Court of Appeal is correct in its conclusion, when the Court of Justice, at paragraph 30 of its judgment, picked out those three specific points as to the amount of interest paid, the extent to which the statutory interest exceeded the principal that had been paid, and the duration of the period over which interest was claimed. By doing that on the Court of Appeal's analysis, the Court of Justice was simply being very obtuse. It was referring to matters that simply made no sense so far as the Court of Appeal's reasoning is concerned. And so I say the Court of Appeal's judgment, by focusing as it does on the notion of reimbursement, fails to look at the judgment as a whole in accordance with the submissions I made in the course of this morning. The other judge, Mr. Justice Henderson, addressed this at first instance and reasoned in a slightly different way. My Lord, his judgment, also volume 9 of the authorities, but this time tab 77. And Mr. Justice Henderson addresses the point from paragraph 253, which is at page 3071.
It's interesting that he concludes, I think, at 299 that there's no satisfactory answer to explain paragraph 30.
Yes, ultimately he effectively has to push that to one side. But in terms of the reasoning he adopted, he makes the point, and this is some way into his reasoning at paragraph 270 on page 3078, that the EU law obligation to pay interest ranks equally with the obligation to repay tax paid in breach of EU law. So 270 on page 3078, Mr. Justice Henderson says this, this passage, it's paragraph 29, makes explicit the proposition which seems to me to be implicit in both Littlewoods and British Sugar. Sorry, I should say it's paragraph 29 of Irami, the Advocate General. Namely, that the right to interest representing an adequate indemnity ranks equally with the right to repayment of the unlawfully levied tax. The description of this right as a subjective right reads oddly in English, but must, I think, mean a personal or private right representing the French droit subjectif. As I was referred in this connection by Mr. Rabinovitz to FHS Bridge, the Council of Europe French-English Legal Dictionary, which under the heading, under the entry subjectif, describes droit subjectif as right conferred on or exercised by an individual, as opposed to a droit objectif. So that's paragraph 270, this notion of the two rights ranking equally. And this is a point that Mr. Justice Henderson then comes back to on the following page at paragraph 274, where he makes the same point by reference to the Court of Justice's judgment in San Giorgio. And you'll see at paragraph 275, he sets out paragraph 12 and paragraph 14 from the judgment in the San Giorgio case. My Lord, just for your note, San Giorgio itself is in volume 2 of the authorities at tab 25, starting at page 1011. Sticking with Mr. Justice Henderson's judgment in paragraph 274, in my submission, the reference to San Giorgio is not really a reference that assists. The court may recall that San Giorgio itself was about the validity of a provision of Italian law that provided for an assumption of passing on, that is to say, that the burden of any overpayment had been passed on by the taxpayer to his customers, and so on that basis could not be recovered unless the taxpayer could demonstrate that he had not passed on the burden of the overpayment. So paragraph 12 of the judgment in San Giorgio, which is set out at 275 in Mr. Justice Henderson's judgment, concerned the right to repayment. And you see from the top of page 3080 that right is described as being an incident of the rule against the effect of national taxes which have an equivalent effect to customs duties, and the fact that those matters could not be charged contrary to the provisions of EU law. The reference to the principle of effectiveness is only within paragraph 14 of the judgment, which is the paragraph that deals directly with the Italian statute and the provision within that concerning the presumption that the burden of an overpayment had been passed on by a taxpayer to his customers. So in terms of the rights ranking equally, the notion that they are both derived from the principle of effectiveness may not take the argument too far. But Mr. Justice Henderson comes back to this point again, this time at paragraph 287 at the bottom of page 3083.
Right.
And he says there, it is for this reason that I have placed so much emphasis on the recognition by the ECJ of the right to interest on unduly levied tax as a right conferred by EU law which ranks equally with the right to repayment of the unlawful tax itself. This is the crucial step forward which the court took in the present case and which it subsequently confirmed in British Sugar and Irami. The earlier theory that all questions relating to interest are normally for the national law alone to determine has now been decisively rejected. It seems to me that the court crossed the Rubicon in relation to interest when it said in paragraph 26 that the obligation of member states to repay with interest amounts of tax levied in breach of EU law is a principle which itself follows from EU law. Now, it may be that one could properly describe the two obligations, one in relation to principle, one in relation to interest, as ranking equally in the sense that each is an obligation under EU law. But in my submission, that description says nothing conclusive as to the content of each obligation. In practice, the content of the right to repayment of the principal sum is self-executing. In most, if not all cases, what has been paid needs to be reversed. Therefore, it's a situation in which, by stating the obligation, you also define the obligation and prescribe its content. By contrast, the obligation to pay interest that's identified at paragraph 26 of the Court of Justice's judgment in Littlewoods does not bring the same consequences in terms of prescription of the content of the obligation. The Court of Justice specifically does not prescribe the content of the obligation to pay interest, and it does not describe the EU law obligation to pay interest in a way that means that the content of that right is self-executing in the same way that the obligation to repay could be described as self-executing. Instead, what the Court of Justice does is to identify the content of the obligation to pay interest only by reference to the two boundary principles, the principle of effectiveness and the principle of equivalence. And so I say that Mr. Justice Henderson's reasoning, based on the notion that each right is a right within EU law, does not support the conclusion ultimately that he reached. I'll try, if I now may, to draw together.
Can I just ask you, insofar as you rely on the principle of equivalence as being the guiding principle, you accept it involves some sort of comparison with something, do you?
Yes, in the sense that the position of the person asserting the EU law right must not be less favourable than the position of the person asserting the equivalent right in an equivalent right in national law.
Well, what is the equivalent right in national law on which you're relying?
Well, I think in this case, I think it's common ground that the principle of equivalence has nothing to say about the content of the right to interest. The argument in this case so far, at least before Mr. Justice Henderson and before the Court of Appeal, on this issue, very much focused on the principle of effectiveness. The court itself referred to equivalence, but made no particular point, left it open as a matter for the court to consider. So far as Mr. Justice Henderson was concerned in the Court of Appeal, there isn't an equivalence issue here that goes to the content of the right within issue 2.
No, because as far as the taxpayer is concerned, there is no better deal available in domestic law.
Quite.
As far as the revenue collecting authorities are concerned, if you can assert an EU right, you get a distinctly more favourable outcome than you would do by applying Section 78, which would apply or its equivalent, if there were
Yes.
an equivalent tax. A Section 78 type regime would be distinctly less favourable to the domestic claimant.
It would indeed, yes.
Yes.
So, my lord, drawing these matters together, the first point is that paragraph 29 of the Court of Justice's judgment cannot be read in isolation from the rest of that judgment. The second point is that the Court's reliance on effectiveness and equivalence is entirely inconsistent with any conclusion that the EU law obligation requires payment of an amount equivalent to the loss of use value of the money overpaid. And similarly, the Court's statement at paragraph 30 to have regard to all the circumstances of the case is, in my submission, a further very strong indicator against that fixed content conclusion. Likewise, the specific matters that the Court then picks out at paragraph 30 for particular attention also point strongly against the conclusion that the EU law right requires a payment that is equivalent to the loss of use value of the money overpaid. The matters that the Court does pick out at paragraph 30, in my submission, plainly point to a conclusion that, taking into account the extended period over which Littlewoods has been able to recover the overpayments of VAT, the amount paid by way of statutory interest was consistent with the principle of effectiveness. And on that point, may I also draw your attention to the opinion of the Advocate General in the Littlewoods litigation. My Lord, this is volume 3, tab 34, and the Advocate General's opinion starts at page 1407. If you would you go to paragraph 30, which is on page 1414.
Yep.
So paragraph 30, which is just above the letter
Yes.
E on that page. In light of these considerations, member states which have levied charges in breach of EU law must, in principle, according to the Court's more recent case law, both reimburse the charges levied in breach of EU law and pay interest in compensation for the unavailability of the sums paid. The taxable person, therefore, has a right to reimbursement of the charge and a right to payment of interest. Those rights enjoyed by the taxable person are based on the provisions of EU law prohibiting the taxes levied. So, the Advocate General, too, concludes that there is an EU obligation to pay interest, quotes, in compensation for the unavailability of the sums paid. She then, at paragraph 31, also identifies the content of that EU law obligation by reference to the principles of effectiveness and equivalence. And then, paragraphs 33 to 37, she addresses the principle of effectiveness. And in particular, if you look at paragraph 37, she there picks out matters that bear a striking similarity to those that were picked out subsequently by the Court at paragraph 30. So she identifies the amount of statutory interest that was paid, the extent by which the statutory interest exceeded the principal sums that have been overpaid, and she also identifies the period over which the overpayments had been made. Now, my Lord, I accept that if you go back to paragraph 34, the Advocate General's language at that point is different from the language of adequate indemnity. At paragraph 34, at the bottom of 1414, she says it is settled case law that the principle of effectiveness prohibits the member states from rendering virtually impossible or excessively difficult the exercise of rights conferred by EU law. In the context of determining the detailed rules governing an interest claim stemming from EU law, a breach of the principle of effectiveness would therefore arise only if the interest was so low that it largely deprived the interest claim stemming from EU law of substance. So it is fair to say that the way in which the Advocate General describes the boundary of the EU law right is different from the way in which the court describes it, at paragraph 29. Nevertheless, in my submission, they are both expressions of the same notion. That is to say, that the principle of effectiveness permits member states a field of judgment within which they can set their own rules. It's plain from paragraph 37 that the Advocate General was entirely satisfied that the requirements of statutory interest were sufficient compliance with the principle of effectiveness. I don't need to rely directly on that because in my submission, in substance, the same point is the only inference that is properly drawn from paragraph 30 of the judgment of the court and the matters within paragraph 30 that I've taken you to in the course of these submissions. So, my Lord, for those reasons, those are my submissions on issue 2.
Sorry, I mean, the following passage was what I was really picking up on, where she discusses the problems of applying the principle of equivalence.
My Lord, yes,
and
yes.
she refers at paragraph 43 to the UK's argument then as to what was the comparison with, and there seems to have been a fairly lively debate with the other intervening governments about that. You seem to be saying that's all irrelevant, which seems a bit odd if she thought it was relevant.
It doesn't give rise to a relevant issue in this case. If you note at paragraph 40, she says there, in order to address the question of compliance with the principle of equivalence, the referring court, which alone has detailed knowledge, etc., must therefore examine whether or not detailed rules governing payment of interest on VAT collected in breach of EU law under section 78 correspond to detailed rules governing similar domestic interest claims. And the point, as mentioned by my Lord Hodge, is that so far as section 78 is concerned, it is a regime that applies regardless of whether the claim comes from some sort of EU law, right, or is actually based on that very little part of VAT law that still rests within the law of the member state. So in practice, there is no equivalence issue in this case, although I accept that the way in which the Advocate General analyses the matter is to address both the question of effectiveness and the question of equivalence in detail.
But in paragraph 43, when you were referring, when the UK was referring to a comparison with interest on unlawfully levied indirect taxes, what were they referring to there?
It would be the indirect taxes referred to in the course of the order made under the Finance Act. My Lord, you recall this morning I took you to the order made under section 197, which
yes.
prescribed the interest rates. VAT is one of the indirect taxes addressed.
So it's that body of indirect tax which are covered.
Within that group are other indirect
yes.
taxes, each of which is subject to the same provision or similar provision.
Yeah. And so and what you were saying, or what the advocate was there saying, was there's no comparable alternative which gives a better rate of interest than one gets there.
Yes, I think in practice, the way in which the arguments of the parties, the observations of the parties were put before the court was very much to focus as a matter of evidence on the question of effectiveness. The question of equivalence, I don't think, was the subject of quite so much, if any, evidence before the Court of Justice, hence perhaps the reason why the Advocate General is able to deal on the evidence with the principle of effectiveness, but in relation to equivalence, is able to do no more than say, well, the National Court must ensure that it's had regard to the following matters. But certainly since the reference has returned, the issue between the parties on issue 2 has focused on the principle of effectiveness, not the principle of equivalence. My Lord, those are my submissions on issue 2. I don't know whether at this stage you wish to hear from Mr. Rabinovitz on issues 1 and 2 as well.
I think what we'll do is we'll go out and consider how we'd like to proceed.
Very well.
So the court will adjourn briefly. Mr. Swift, I think for the moment, subject to what you and Mr. Rabinovitz say, we think we would like to hear Mr. Rabinovitz on issues 1 and 2 at this stage.
Well, before I sit down, I was asked for references on equivalence.
Please, yes.
My Lord Carnworth, the Court of Appeal addressed the question of equivalence, if I could just give you the reference.
Sorry?
The principle of equivalence was considered by the Court of Appeal.
Yes.
My Lord, the reference is Volume 9, Tab 78. It's paragraphs 133 to 135, which is at page 3176.
Yep. And you don't want to say anything about that?
My Lord, no.
Mr. McNabb, anything you want to add? Sorry, Mr. Rabinovitz. Mr. McNabb, anything you want to add? No, thank you. Sorry, Mr. Rabinovitz.
My Lords, issue...
Are you content to proceed?
Absolutely content, my Lord.
Thank you.
Issue 1. As your Lordships know, this is a straightforward question of statutory interpretation. And perhaps I can just begin by inviting your Lordships to take up Bundle A1, just to look again at the two relevant provisions.
Of course.
A1 tab 17
Yep.
for section 78. Learned friend took it from the version starting at page 927.
Yep.
And what your Lordships have in section 78, where due to an error on the part of the Commissioners, a person has, and then it identifies 4 ways in which the revenue may be accountable to the taxpayer. The Lordships may want to focus on, for the moment, on B, fail to claim credit under section 25 for an amount for which is entitled so to claim credit, and which they're in consequence liable to pay. And just to note there, that is not a claim that you can make under section 80. We'll come back to that. So one has these 4 grounds identified in relation to which one might be able to claim the VAT back. And then you get these words, where due to an error on the part of the Commission, a person has one of these claims, if I can put it that way, then, if and to the extent that they would not be liable to do so, apart from this section, they shall pay interest to him on that amount for the applicable period, but subject to the following provisions of this section. And I think my learned friend took you to various provisions. There is, I should identify also, I think, a limitation provision, subsection 11. I don't think that matters for present purposes. In our respectful submission, my Lords, the determination of issue 1 depends upon how your Lordships interpret the closing words of section 78.1. Can I just begin by telling your Lordships what we say about that, and then I have to identify the 4 ways in which so far it has been suggested we cannot be right. Now, what we say about this provision is that what you have here, and in particular by reference to the closing words, if and to the extent that they would not be liable to do so apart from this section, is language that can be given an ordinary meaning, and if the ordinary meaning, natural meaning, is given to these words, section 78 and the right it introduces is to be understood to be a residual and subordinate right. It is a residual and subordinate to other claims that may exist against the revenue for interest. In terms, section 78.1 expressly yields to other rights which come into the if and to the extent that they would not be liable to do so apart from the section. In our respectful submission, it is impossible to give those words any other meaning. Now, as your Lordships know, just standing back, what one actually has with section 78.1, I'll come back to whether it's an exhaustive code and how it works with section 80 in a moment. What you actually have with section 78.1, introduced as it was in 1991, is the government giving taxpayers an additional right which is residual and subordinate to any other right that might exist to claim interests. And the issue for your Lordships is whether the right that my clients pursue for interest is such a right that comes within the words, those words. Now, that's probably a convenient point to identify the 4 different ways in which it has been suggested that my clients are precluded by section 78.1 from bringing their common law claim for unjust enrichment. One first has, as my learned friend showed your lordships this morning, Mr. Justice Henderson in chalk. Now, the way in which Mr. Justice Henderson in chalk sought to analyse these words was to consider that I'm going to call them the closing words, to consider that what those closing words captured were simply other claims for interest which fell within the VAT Act. And I think my learned friend explained to your lordships this morning that in the VAT Act under section 84, I think it became section 85, there is a right to claim interest. We have section 85, section 84, is it section 84? 85A, I'm grateful. If your lordships go to tab 16, and your lordships go to page 919. And just if your lordships glance at section 85A, looking at page 919, this section applies where the tribunal has determined appeal under section 83, where on the appeal the tribunal has determined that the whole or any part of any disputed amount paid or deposited is not due, or the whole or any part of any VAT credit due to the appellant has not been paid, so much of that amount or that credit as the tribunal determines not to be due or not to have been paid shall be paid or repaid with interest. Now, again, your lordships may want to note that that would not be under section 80 either. Now, just going back...
Did such a provision exist before 1st April 2009?
1st April 2009.
Yes, this version. Was there a previous 85?
Yes, I think there was, my lord.
All
I think
right.
it was section 84 before that.
All right.
Section 84, subparagraph 8. If your lordships go to...
Thank you. Don't worry. Yes, I see. Okay.
So, again, the point there is that doesn't arise under section 80 either, and that's going to be relevant to one of the points I make. But so far as Mr. Justice...
Does it fall under any of the other things in 78.1? A, B, C, or D?
Mr. Jones tells me it could be a credit, my lord. So it could have fallen under section 80.
So 85A does give it some meaning.
85A certainly does give it some meaning. We are not saying that it doesn't have meaning unless you allow the common law claim here. Effectively, our position is there is no basis for distinguishing between statutory claims, which give rise to claims for interest, which arose against, which could have been brought against the revenue, and common law claims. There's just nothing in the words which enable one to get to that conclusion. But if I can just go back to identify the four ways in which it's been found against us, as I say, Mr. Justice Henderson in chalk
85A.
says section 85A and only section 85A. So far as Mr. Justice Henderson is concerned, to the extent the only other place you can look for a claim for interest against the revenue is under the VAT Act itself. Now, and I think my learned friend has given you the references to chalk.
Yes, he has.
That then goes in front of Mr. Justice Voss at first instance in Littlewoods. When it gets to Mr. Justice Voss at first instance in Littlewoods, Mr. Justice Voss has brought to his attention two cases which were not brought to the attention of Mr. Justice Henderson in chalk. They are the cases of Elite Mobile and Mobile Export. Now, both of those cases were judicial review claims brought against the revenue, as a consequence of which the court concluded, looking at how you construe section 78, that section 78, or those saver words, if I can put it that way, at the end of section 78, were not limited to claims for interest which arose within the VAT Act, but they also included section 35A of the Senior Courts Act, at the time the Supreme Court Act. Now, those were the decisions of Mr. Justice Collins and Mr. Justice Lindsay. If I can just give your lordships the reference to those, Elite Mobile is at A10 tab 81, and Mobile Export is at A10 tab 82. And those judges were in no doubt that what one was dealing with Section 78 was a residual right to bring a claim under Section 78 to the extent that you didn't have a right outside of Section 78 to bring the claim for interest. That is why, when the matter came before Mr. Justice Voss, at first instance in Littlewoods 1, Mr. Justice Voss didn't follow what Mr. Justice Henderson had determined, which was to limit the scope of the remainder words to claims that you might have for interest against the revenue under the VAT Act. Mr. Justice Voss accepted that not only therefore would it include Section 85A, but it would also include Section 35A of the Supreme Court Act, Senior Courts Act, which meant that the way in which Mr. Justice Voss interpreted the words then, if and to the extent that they would not be liable to do so, was by reading in effect, I'm not saying there's anything illegitimate about this process, but there's no question that this is what he did, by reading in to the words that you see at the bottom, then if and to the extent that they would not be liable to do so apart from this section, the words under a statute. Because you don't find anything in those words which would suggest that where it says, then if and to the extent they would not be liable to do so apart from that section, it is limiting itself to a statutory basis for a claim. One then gets to the Court of Appeal, and I'm going to take you to the Court of Appeal. The Court of Appeal was not much impressed, I would suggest, with the approach either taken by Mr. Justice Voss or indeed Mr. Justice Henderson. No one is any longer suggesting that Mr. Justice Henderson was right. What the Court of Appeal did instead was to say, no, it is possible that you could have a common law claim that could come within these words, but your claim is not a claim for interest. And therefore, because your claim is for the time value of money, then it is not a claim which would come within the words, if and to the extent that they would not be liable to do so apart from this section, they shall pay interest, but subject to the following provisions. So the Court of Appeal sought to draw a distinction between the claim that my clients are bringing and a claim for interest. Now, your lordships will have noted that my learned friend does not appear to support at all that reasoning, but I'll come back to it because it's irrelevant. That my appeal is against the Court of Appeal decision and the reasoning in the Court of Appeal. So that's the third of the basics. The fourth go, if I can put it that way, is that which is made by my learned friend, who neither supports Mr. Justice Henderson, nor apparently does he support the Court of Appeal. And this makes sense, because what he says is that your lordship should take into account Section 80, subsection 7. And that because of the existence of Section 80, subsection 7, we don't have a common law claim which could come within the section. And you can see the tension between my learned friend's position and the position that the Court of Appeal adopts. The Court of Appeal say, and I'll take you to the reasoning, the Court of Appeal actually deal with my learned friend's argument, and they say he's wrong about Section 87. I'll show you that now. They say he's wrong about Section 87. You do have a claim which you can bring, because a claim for interest is independent of a claim for repayment of the VAT. It has an independent life. I'll show you, Lordship, where they say this, based on Sempra, and rightly so in our respectful submission. And they say it therefore has nothing to do with Section 80, subparagraph 7, which is dealing with claims for repayment of overpaid VAT. Nothing to do is to put it too strong. But where you have a claim for overpaid VAT, you come within Section 80, and I'll show you Section 87 now, where your claim is not for the repayment of overpaid VAT, but it's for interest. Your claim is under Section 78. So the Court of Appeal say that Littlewoods was right to say that there is that Section 80, subparagraph 7 doesn't really help, but they say your claim is not a claim for interest. Now, with that introduction to the smorgasbord, if I can put it that way, of reasons why you should not give this language its natural and ordinary meaning, can I take you next to the Court of Appeal, just to show your lordships what the Court of Appeal
Yeah, of course. Yep. Let's do that.
If I'm going too fast on anything, your lordships want to slow me down, please do. 'Cause,
Not too fast at all, don't worry about that.
if I'm going too slow, please speed me up. Court of Appeal, can I invite your lordships, in relation to the Court of Appeal, just to go to
Article 9, yep.
well, 9, or if you want to, I don't know whether your
in the
lordship
core bundle, yeah.
Core bundle. The references I have are in the core bundle. I'll give you both references.
Anyway, that's fine, yeah. If you get, once we find it, the paragraph numbers will be great.
Go for my lord. Core bundle, if I can.
Of course.
I'll give you references to the other as well.
Yep.
This begins, I think, on paragraph 31.
31, right?
Full reasoning. After setting out, I think, between paragraph 16 and 20, your lordship see the relevant statute set out. Paragraph 31.
Yes.
Your lordship see this. There can be no doubt that section 80 provides an exclusive statutory scheme which deals specifically with a case where a taxpayer claims repayment of a tax which is not due. And can I just be clear? We don't dispute that for a moment. We absolutely are, we accept entirely.
You say you've got a freestanding claim for interest.
Precisely that.
Yep, understand.
Thus, Section 81 imposes statutory duty on HMRC to credit the taxpayer with the amount of overpaid tax. The liability to repay imposed on HMRC by Section 81 is to the exclusion of any other liability to credit or repay any amount accounted to for or paid to them by way of VAT that was not VAT due. And then it says the net effect of these provisions that the only cause of action available is Section 81. And then the Court of Appeal agrees with Mr. Justice Henderson that Section 87 would bar claims for repayment. Then they deal with a point I can come back to. It follows, just picking up at 34, if Littlewoods' claims are to escape the scope of Section 78, they must come within the scope of Section 78(1), reservation properly construed, and we, with respect, agree with that. And then between paragraphs 35 and 43, the Court of Appeal deal with, in effect, the argument that my learned friend seeks to continue to press before your lordships, and I wonder if I can take you through that. We first consider HMRC's argument that Littlewoods do not have a common law claim which can take advantage of the Section 78 reservation. We have already explained that Section 87 unequivocally ousts any common law claim Littlewoods have to the return of the principal sum on the basis of restitution, whether by way of woolwich or mistake-based restitution. Do Littlewoods nevertheless have common law restitution claims for interest? HMRC's suggestion that they do not was not argued before Mr. Justice Voss, but no objection was taken to the point being raised before us. It is plain that any claim for interest must be founded on the claimant's right to return of the principal sum. But for Section 87, Littlewoods would encounter no difficulty with the contention that they could claim in restitution for the principal sums overpaid and for interest on those sums. That conclusion follows from Sempra. Sempra also makes clear that the fact that the principal sums are repaid is no bar to a claim for interest. The principal speech in Sempra on this aspect is that of Lord Nichols. In the paragraphs culminating at 100, Lord Nichols considers the anomalous situation created by the common law exception of claims to interest when assessing damages. He concludes at 100, the court has a common law jurisdiction to award interest simple and compound, as damages on claims for non-payment of debt as well as other claims for breach of contract and in tort. Lord Nichols then turns in a section headed interest, benefits and restitution to consider the corresponding rule in restitution, which was that no interest, whether compound or simple, could be recovered at common law in an action for restitution, although simple action might be recovered in equity. At paragraph 112, Lord Nichols held that the court has power in the exercise of its common law restitution jurisdiction to make an award of compound interest. For present purposes, what is important is Lord Nichols' analysis of Sempra's claim at 102. The benefits transferred by Sempra to the Inland Revenue comprise, in short, 1, the amount of tax paid to the Inland Revenue, and 2, consequentially, the opportunity for the Inland Revenue or the government, of which the Inland Revenue is the department, to use this money for the period of prematurity. The Inland Revenue was enriched by the latter head in addition to the former. The payment of ACT was the equivalent of a massive interest-free loan. Restitution, if it is to be complete, must encompass both heads. Restitution by the revenue requires 1, repayment of the amount of tax paid prematurely, and 2, payment for having the use of the money for the period of prematurity. Now, what one finds here, and it carries on, is the House of Lords in Sempra making clear that these are 2 separate heads of damages, and they have an independent existence. My learned friend concentrates on the fact that had there not been an overpayment of capital, there could not have been a claim for interest. And with respect, he is completely right about that. Right, but irrelevant. It is nothing to the point. Just as in Sempra, the fact that there was no longer a claim for principal was nothing to the point about whether there was a claim for interest. So too, under the common law, because that's what we're talking about, in relation to our claim, the fact that any claim we might have for capital or repayment of the overpaid VAT, was barred by Section 80, subsection 7, is nothing to the point in terms of our independent claim for interest. The fact that they are causatively linked to the same event is neither here nor there. It doesn't in any way deny the independent existence recognized by SEMPRA of a standalone claim for interest. And that is what Section 78, subparagraph 1 is dealing with, as opposed to Section 80. I'll just carry on if I may. SEMPRA was a case about prematurely paid taxes which were ultimately set off against the liability to the revenue when those taxes fell due. This did not affect the liability to pay interest, as Lord Nichols explained. Further, as with damages claimed in the present proceedings, so also with the two restitutionary claims, no difficulty arises from the fact that SEMPRA's ACT payments were mostly used before the inception of the proceedings. The Inland Revenue had the benefit of the use of each payment of ACT for at least 8 months. Setting off a payment of ACT against SEMPRA's mainstream corporation tax liability did not extinguish the Inland Revenue's restitutionary liability in respect of the interest benefits it had by then obtained from the ACT payments. So again, the identification of the fact that the extinction of one does not extinguish the other. Lord Hope, paragraph 25, the unjust enrichment principle supports the freestanding cause of action to recover interest, which is the measure of the enrichment. And again, just pausing there, the basic point that my learned friend was making to the Court of Appeal and makes to you now is that because my clients could not have pursued a claim at common law under Section 80 at all, because of the effect of Section 87, that means in some way that they can't pursue a common law claim for interest. And with respect, it is clear from what Lord Hope is saying that he would certainly not agree with that analysis. The claim for interest is a freestanding cause of action. The claim is a freestanding cause of action to recover interest. And one then gets Lord Walker agreeing with this. Now, I'm not sure I need to read your Lordship's the quote from Lord Walker.
Two questions occur to me, Mr. Rabinowitz. First of all, SEMPRA Metals was new law, wasn't it, really?
SEMPRA Metals was new law, yes.
So when this Act was, when Section 78 was drafted, 97 to 2005, SEMPRA Metals wasn't in the mind of the draft.
1991. Section 78.1 was 1991.
Well, no, well, exactly. So there was a pre-SEMPRA Metal idea.
My Lord, your Lordship is right in this sense, and I was going to come to this, but I'm very happy.
If you're going to come to it in due course.
I am going to come to this. But this is Mr. Justice Voss's nonsense point. The suggestion that because of the development of the common law, it makes Section 78 OTOs.
Well, that was my next question, yes, which is what do those words cover that you've been concentrating on at the end of Section 78.1, if there is a common law right to interest for any money it's wrongly paid,
What do which words cover, my Lord?
Well, if and to the extent they'd not be liable to do so apart from this section.
I mean, what don't they cover? Because if we're right, we're right, and
Well, when would they not apply?
When would they not apply? Well, they might apply if there is no restitution claim for a variety of reasons. And there may, for various reasons, be a defence to the restitution claim. There may not have been a mistake, and there may not be a Woolwich claim. But let's assume...
But we're talking about interest here. When
Indeed.
Would the money be due and paid? On your case, there'd always be a right to interest in common law.
There is always a right to interest at common.
Therefore, when does Section 78 apply?
Well, it may be, my Lord, that it seldom, if never, applies. But that is not a reason to decide that the words can't mean what I say they mean. And I don't mean that in an Alice in Wonderland sense. I mean it in the sense...
No, I understand. It's not Humpty Dumpty. You're arguing. Yeah.
The point is this. It's a point which comes up in the cases repeatedly. One has a statute which, at the time it is written, has in mind that certain remedies may be available to a particular party, and it creates an additional remedy. Now, it turns out that when the draftsman creates the statute, he makes a mistake, and that's the effect of the declaratory theory, because he doesn't take into account, when he makes the statute, that there is in fact a common law claim which would make the additional claim that he's giving you under Section 78.1 an unnecessary claim. It's been said repeatedly, including by this court, that the developments in the common law even if they have the effect of making a statute perhaps less important, perhaps even redundant, are not a reason to give the language that is used in a statute a meaning which is different from the natural and ordinary meaning in that statute. One can't say that because the common law has developed, and it has developed since then, three things have happened since 1991. The first is Kleinwort-Benson in 1992, which enabled parties to claim on the basis of a mistaken payment. Now, that in itself wouldn't make any difference to this. The second is DMG, which in effect made it clear that the claim for mistake extended to claims against the revenue as well. And the third is SEMPRA. So DMG, I think, was 2007, 6, and SEMPRA was 2007.
7.
Those are three developments. Now, the effect of those three developments might mean that the additional right which the government intended to provide when it gave Section 78(1) is not needed at all. But that doesn't mean that one should read in a limitation into these provisions which could not have been intended in 1991.
You said there's plenty of statements as a fact. Can you give the best?
Well, let me give Monroe is probably the best, and perhaps I can just show your lordships Monroe. If your lordships take volume A9,
Yes.
the lordships have Monroe at paragraph 79.
Sorry?
Tab 79.
Thank you very much. 3197, yep.
And perhaps the best passage to look at is paragraph 3 on page 3201.
Thank you.
Legislation is always enacted against the background of the common law, so there is always a risk. Sorry, I'll just wait. Legislation is always enacted against the background of the common law, so there is always a risk while this legislation is in force, the common law will change in some material way and with retrospective effect. The relationship between the common law and the statute often gives rise to problems. The fact that Parliament was ignorant about the common law may, for example, throw light on the meaning of a provision, but the court cannot adopt a different approach to the interpretation of a statute simply because the common law has developed since the statute was enacted, or because Parliament may not have fully appreciated recent developments in the common law. The court cannot rewrite the scheme. The court has thus to take the words and structure, this is about section 33, but in our respectful submission, exactly the same thing applies here. Now, my learned friend, I think in his submissions...
So could you give me what was the page reference for that again, please?
The reported page reference.
Yes.
So it's 2009.
328, yes.
2009 Chancery Division.
No, sir. 3201.
3201.
I'm sorry. It's paragraph 3 at 3201.
Is there any authority in the House of Lords or this court on this point?
Kleinwort-Benson, my lord, volume 8, tab 73.
Thank you.
Perhaps I'll just show you, Lord, that. That related to mistake of law, obviously. If I can just take your lordship there, and then I'll explain where this arises. Tab 73. Now, again, your lordships will recall that Kleinwort-Benson was the seminal case which said claims for unjust enrichment do not only extend to mistakes of law, mistakes of fact, they also extend to mistakes of law. And that, I think, reversed many years of decisions where effectively the way the courts had dealt with this absurdity, where this distinction was being drawn between mistakes of fact and mistakes of law, was by creating ever more exceptions to the rule against no claim in unjust enrichment for a mistake of law. In Kleinwort-Benson, the House of Lords said you can bring a claim for mistake of law in the law of unjust enrichment. And the question that then arose was whether, in relation to a mistake of law claim, you could come within section 32(1)(c) of the Limitation Act, because the whole purpose of, perhaps that's an overstatement, but one of the things the party would want to do by pleading the claim in mistake is to take advantage of the extended limitation period in 32(1)(c). The defendant in Kleinwort-Benson, as a kind of last-ditch argument, said, well, there may be a mistake of law claim, but when section 32(1)(c) was enacted, no one thought there was a mistake of law claim. They thought that the only claim you could bring based on a mistake was a mistake of fact claim. And on that basis, the submission was made. Therefore, having regard to what the legislature would have thought when it passed Section 32(1)(c), I guess it's 1982, is it? You cannot bring the mistake of law claim within Section 32(1)(c), and that was roundly rejected by Lord Gough between paragraphs. It's page 388, paragraph. Well, it's no paragraph number. It's top of 389, really.
2873.
2872. I'm so sorry, my lord. Yeah, 2872 on to 2873.
Can I ask, was Section 78 enacted before Kleinwort-Benson?
Indeed, long before Kleinwort-Benson. Section 78 was enacted in 1991. Kleinwort-Benson, as your lordship sees, is 1999.
Yeah. Yes, I see. So it wouldn't have been envisaged that there would be any liability to reimburse a common law where there had been an error of law.
And in fact, it really is sempra rather than anything else which matters. And as I indicated a moment ago, that's 2007. So this is enacted 16 years, if I've got the maths right, before sempra. As I say, Mr. Justice Voss said my submissions make a nonsense of Section 78. One needs to understand in what sense he says it makes a nonsense. It doesn't mean my submissions make it impossible to read Section 78 by reference to the natural and ordinary language of the words. He means it makes it otiose. It is not a statute which was intended to give an additional right where that additional right is likely to be necessary.
Well, I think in fairness, if one reads what immediately precedes the paragraph you've drawn to our attention on 389, it isn't quite the same point, because Lord Gough says at the bottom of 388, top of 389, that it was appreciated that 32(1)(c) applied to mistakes of law. The very last sentence of the paragraph before the one, very bottom of the page. All he's saying is they may not have appreciated the full effect of it, not that they didn't appreciate it and apply to mistakes of law.
But then he says this verbal argument founders on the fact that the pre-existing equitable rule applied to all mistakes, whether mistakes of fact and mistakes of law. I recognise that the effect of Section 32(1)(c).
Yes, but just stopping there, it's almost as if he would accept the argument if it hadn't been for that.
With respect, my lord, in my respectful submission, well, the way I would submit that your lordship would read this is to say he wouldn't accept that argument.
Well, he said this verbal argument founders on the fact that pre-existing equitable rule applied to all mistakes, whether they were mistakes of fact or mistakes of law, i.e. it did apply to mistakes of law even before Kleinwort-Benson.
But
all they did was to expand the mistake of law concept, is what he seems to be saying.
He then goes on to say, I recognise that the effect of Section 32(1)(c) is the cause of action in a case such as the present may be extended for an indefinite period. I realise that the consequence may not have been fully appreciated. Indeed.
The point he's making is that it did apply to mistakes of law, but only in equity, but now it applies in common law as well. So it's not quite in point.
Well, it's not quite the point, and perhaps the way it's put by Lady Justice Arden in Monroe is clearer.
Yes,
but in my respectful submission, what she's saying must be right. You can test it this way, my lord. Take a situation. If my learned friend is right that the only things that can come within those saving words are words that the legislature, notwithstanding the generality of the words that they've used, if my learned friend is right that notwithstanding the generality of the words that they use, the only types of claim that could come within those words are claims that in 1991 the government foresaw, then one can imagine a situation in which a new statute is passed, separately from the VAT Act, which gives a claim for interest against the revenue, outside of the scheme. On my learned friend's reading of this, that statutory right to claim interest would also not be, if you like, saved by these words. They would be precluded on the basis that that wasn't in anyone's mind. That particular cause of action wasn't in anyone's mind in 1991.
But, well, I think his argument accepts that statutory rights of interest are in a different category. His argument really is that to allow common law claims for interest to fall within the scope of the exception would turn the exception into the rule.
And I understand that. That's Mr. Justice Voss's nonsense point. And that may be a consequence. The answer to that, you have a statute in 1991. It is overtaken by the events of the common law. The answer to that is an amendment to the statute, if this is no longer what the revenue wants to happen. They can amend the statute so as to specifically exclude common law claims. But the fact that this may not be what anyone had in mind doesn't mean that your lordship should not give these words their natural and ordinary meaning.
What you're ultimately saying is that Section 78(1) was intended to ensure that people who didn't have a right to interest otherwise would have a right to interest.
Exactly that.
What Parliament didn't realise was a lot more people had a right to interest than they thought at the time.
That is it.
But so what?
That is it. And if they don't want these extra people to have this extra right outside of Section 78(1), they have the remedy in their hands.
Well,
They amend it.
what, they should have done it retrospectively to knock out all claims back to 73.
Well, that may depend on whether we're still in Europe or not, and whether I have a European right. This government or this parliament, or certainly the HMRC, are not beyond retrospective legislation to knock out rights. This court knows it from FII, where they were not trying to knock out a claim under DMG retrospectively. Now, whether they can do it retrospectively or not is neither here nor there. They can certainly close the gap if they don't like it. But in my respectful submission, what your lordship should not do is give these words some meaning which is different to the natural and ordinary meaning of these words, simply because it produces a result which is not the result foreseen by the revenue. Because that is not a proper approach to
Statutory construction.
statutory construction.
There was reference this morning to the Law Commission. Are you coming to that?
We had a look for that, and with respect to my Lord Reid, the Law Commission was 1995.
Yes, it comes afterwards.
And actually, just in terms of that, the Law Commission said there should be no defence of disruption to public finance. So to the extent that one is to get anything from the Law Commission, I'm not sure that one can, save as an indication to your lordships that this is not what, if your lordships are concerned about disruption to the public finance and you're taking a route which is not the route that the Law Commission said. Sorry, I'm gabbling a little bit. The Law Commission was in 1995 and therefore can't really help it in terms of what was intended in 1991. The Law Commission related to, it's referred to in ITC, it related to a report as to whether changes should be made to legislation, including Section 80, as a result of the possibility of mistake of law claim and a mistake of fact claim. And the Law Commission, I think, recommended changes to the law to deal with the consequence of changes, claims based on mistake. But what it recommended against was any introduction of a disruption to public finances defence. So the Law Commission certainly doesn't help my learned friend.
Is there any, do any of the other members of the House refer to the point that Lord Gough makes in page 388 and 389?
I don't think they do.
And presumably there's something in Benyon or one of the textbooks.
There is. I was going to, those of you who are in ITC will remember that in the context of ITC, there was a reference to a judgment by, I think, Lord Bingham in, I think it was called Quinterville. This is the cats and dogs example, or cruel and unusual punishment. And it's the point about statutes always talking. Now, the point that was made there by Lord Bingham, and I think he refers also to an earlier judgment by Lord Wilberforce, is that if you have general words in a statute, I think the example he takes is a dog. If you have a statute which talks about a dog, the genus of a dog, and at the time the statute is passed, no one recognizes, no one regards a particular species as a dog, but subsequently they do accept that the species is a dog, then it comes within the words, even though at the time it was enacted, no one thought that that species was a dog. Now, I'm not calling my claim a dog at all. I respectfully submit it's a rather good claim. Both courts below have decided. But it does come within the genus of the words, the general category of words that are used here. They're not specific. There is nothing in that language that can possibly be interpreted as limiting the claims which are being saved or the claims to which Section 78 are residual as being limited to statutory claims.
Is it right that the sempra metals necessarily applies to a right given by statute?
I'm not sure that it, with respect, my Lord, your Lordship's point, I think, may miss the point which is being made against me.
No, it's a point. I'm not
the answer is I don't know.
I'm putting a point to you. What I'm putting to you is that you are given this right under Section 80 to recover the money. And you are saying that sempra extends a common law right to interest because you're given the right under Section 80 to the capital.
With respect, no. I do mean that with respect.
We
have a right at common law in relation to the claim. If I can just start from a point slightly before your Lordship starts.
Yes.
What SEMPRA shows is that, I'll come to the effect of Section 80 in a moment, because Section 80 precludes my common law claim for repayment of the capital. So I have a common law claim for repayment of the capital, subject to Section 80, as well as a common law claim for interest. The effect of Section 87, subsection 7, because it's an exhaustive code, prevents me bringing my common law claim for repayment of the capital. But it says nothing at all about my common law claim for interest.
Well, what it says is you've got no common law claim, you've got a claim under Section 80.
But you can't say, it says I can bring no common law claim. It doesn't mean that as a matter of legal analysis, I wouldn't, but for Section 80...
It says the commissioners shall not be liable.
So it prevents, the effect of Section 87 is to prevent liability in respect of my common law
Therefore,
claim.
there is no liability to pay you.
I'm accepting that. But
therefore, your claim is under statute for the capital sum. And I can't quite see how if you've got no claim in common law, why you've got a common law claim to interest based on the common law claim for capital that you haven't got.
Well, because it's not based on the common law claim. I have a
right. It's a statutory claim to a capital sum.
The effect of the statute is to preclude any common law claim and to give me a statutory claim instead.
Yes, and what I'm asking is, does Sempra Metals give you a common law claim for interest on a sum which you can only claim under a statute?
In my respectful submission, yes, it does. Because in the passages that I've taken your lordships to, Lord Hope and Lord Nichols, they talk about an independent common law claim for interest, which is, and I say independent because if you look at Sempra itself, in Sempra there could not have been a claim for the capital because the capital had been, which was for advanced corporation tax, by the time the claim is issued, the capital had been repaid or used up. So there was not in existence a common law claim for the capital. But that did not preclude a common law claim for the interests. That is the effect.
But the difference there in Sempra, the common law claim for capital had been met. It existed and had been fulfilled. In this case, there is no common law claim for capital. You're not asserting that the right of restitution, you're not accepting the Court of Appeal's argument that the right of restitution is anything other than a claim for interest. Therefore, it seems to me that Lord Neuberger's point remains one to be considered.
Well, let me have another go at that. In Sempra, your lordship says it had been met. It didn't exist at the time the cause of action, the time the claim form came to be issued, because the capital had been used up in corporation tax. It was paid as advanced corporation tax, that's to say early. By the time anyone realized what was happening, corporation tax was due. There was no claim for the capital. It may be that theoretically there could have been a claim for the capital had it not been repaid, but it had been repaid. That means that at the date the claim form was issued, there was not in existence any possibility of a common law claim to recover the capital.
But the point that, sorry, please.
Well, so the unjust enrichment consisted solely in the prematurity of the payment of the tax.
Exactly that.
And so the enrichment was a benefit derived from the premature payment, and so the restitutionary claim was for the value of that benefit.
Precisely that. And it was independent, as is repeatedly reiterated, of any claim for the capital. There was no claim for the capital. Just as here, we have no claim for the
Yes,
capital.
but in that case, I may misremember, didn't in Sempra, didn't they make the point that the old idea that the notion, forgetting statutory intervention, that if you were repaid a sum you were owed, you couldn't then claim the interest, had gone, and the fact that the sum has been repaid, doesn't prevent you claiming interest you would otherwise have been able to claim if it hadn't been repaid.
That was one of the things that Sempra did.
But in that case, why does it help you that the sum was repaid and couldn't be claimed? Because if the claim for interest was freestanding anyway, it doesn't matter.
Well, it depended in any event on the fact that just in the same way as my claim here depended on an overpayment of VAT, so too in Sempra, the claim for interest depended on an overpayment of a payment of ACT. It wasn't freestanding in that way. It depended on a claim which certainly at the time the claim for interest was brought no longer existed. In that case, it no longer existed because it was repaid. In my case, you could say no, I couldn't bring it because it was precluded by Section 87. In my respectful submission, the important issue that comes out of Sempra is that you do have a freestanding claim for interest. And in my respectful submission, the point that my Lord Neuberger makes actually assists me in that regard. Because in effect it is saying you don't need a claim for capital in order to bring a claim for interest. They are freestanding and independent.
Well, I think you would normally, at any rate, have had to have the claim. It just has been satisfied in some ways. Lord Reid said in that case by effectively by being satisfied, but in most cases by being paid.
Well, here I would effectively, at common law, I might have had a claim, but it's precluded by the statute. Now, in my respectful submission, in the one case it's precluded by the statute, in the other case it's precluded by being repaid before I bring the claim. Neither of those detract from the fact that what one is dealing with as a matter of the common law is a freestanding claim for interest. And that is what Section 78 is addressing, as opposed to Section 87.
Can you, I understand the way you put it, and it may not matter, but is there any legislative policy reason for barring the claim, the common law claim to principal, but leaving open a completely unlimited claim to interest, which is the effect of your argument? You may say it's just they didn't think about it at the time, but is there any legislative policy reason for doing it that way?
A policy reason for treating a claim to interest as available if the claim to capital is not available.
Well, yes, it's a matter of statute. You provide a specific code. This is what we said in ITC for the principal. It doesn't seem to make much sense then to leave it open, to have a completely unlimited common law claim to the interest.
My Lord, your Lordship is putting to me something which, although it may look like it makes not much sense now, that is because of developments in the common law.
No, I understand your point that it doesn't really matter. This is history. I'm just wondering whether you could bolster your case by pointing to some legislative policy reason why it might be a sensible way to deal with it.
I think that may be a bootstraps argument.
One of the points made against you is that we have the statute as it is, and we have to construe it to make sense. So we've got to construe Section 8 and Section 78 together.
Indeed.
And try and make sense of them.
Indeed. But my learned friend, and this is another argument he makes in his three arguments, he presses your Lordships to accept that these two provisions are intended to work in tandem in all respects. But they don't, and they were never intended to work in that way. There are plainly circumstances in which Section 78 will give a claim for interest when Section 80 does not operate, and I've already referred your Lordships to Section 78(1)(c). And there are occasions where you have a claim under Section 80, your interest will not be under Section 78. Section 35A of the Superior Courts Act.
Senior.
I keep thinking of it as the Supreme Court Act in the old money.
Supreme Court Act.
Senior Court
Senior.
Act.
Senior Court Act.
So the notion that these provisions were intended always to work in tandem with respect is wrong.
This comes from Mr. Justice Collins's case.
The reliance on
Should we have a look at that?
Indeed. I think I said they're in volume 8. 10, right? Okay. Your Lordship will give me a moment just to give you the references. Volume 810, tab 81. Thank you. A10 tab 81.
10, Peter.
10. A10 tab 81.
No, 810, sorry.
And if I can just tell your Lordships briefly what this was about, your Lordships have it. The case concerned a claim made against the Commissioners in respect of 2 input tax credits amounting to over £5 million. HMRC had failed to give effect to the credits, and the taxpayer brought judicial review proceedings. This caused HMRC to reconsider, and they agreed that they would pay the £5 million together with interest under Section 78 of the VAT Act. But the taxpayer was not happy with the Section 78 rate, and he wanted the rate applicable under Section 35A of what was then called the Supreme Court Act, 1981. And so the issue squarely before the court was whether it was only pursuant to Section 78 that any interest could be claimed against the revenue. Obviously, if Section 78 with or without Section 80 subparagraph 7 was a complete code, then such a claim could not succeed. And Mr. Justice Lindsay, as I'll show you, Lordships, had no difficulty in saying that Section 78 was not a complete code, and therefore a claim for interest under Section 35A could be brought. If I can invite your Lordships to look first at paragraph 13. To page 3319, it is to be noted that the liability under Section 78(1) will yield to some other provision for interest if that other creates a liability to pay interest at whatever rate for the same period and on the same amount. And that's the point I was making about it being residual. If I can then invite your Lordships to go to paragraph 33. Page 3325. I have not been taken to any legislative rules or provisions as to refunds in any such case, nor to any provisions for security for the refund that it would at least arguably become due to customs, nor to any provisions meeting the possible case that the recipient of the interest had ceased to be a payer of VAT. Had it been foreseen by the legislature that interest might become payable under Section 35A at rates higher than the Section 78 rate, one might reasonably have expected to find some provisions. The absence of such provisions, coupled with the undesirability of double claims, first for the payment of interest and then for the repayment of excessive interest, point towards a view that the rate that should be ordered, if Mrs. Hamilton's argument is right, over the relatively short period under the position under Section 79 is established should be the rate applicable under Section 78. But even if that approach is unjustified, it is to be remembered that the judgment rate is no more than a convenient starting point for fixing a rate under Section 35A. As for the other factors taken into account, I accept Mrs. Hamilton's argument that the provisions in the VAT Act, and in particular Section 78, are not an all-embracing code as to the payment of interest, a code which precludes any other provisions on the subject. I agree with her that the words, if and to the extent that they would not be liable to do so apart from the Section 78(1), point to there being no such exclusive code. But that, as it seems to me, is far from saying that regard need not be had to the rates payable under Section 78. So effectively, he looks at the words and he says, well, they're certainly wide enough to capture Section 35A.
Can I just ask for information? Under Section 80, there's provision made to prevent unjust enrichment of the taxpayer. And effectively, the people who actually paid the VAT can be reimbursed. Is there anything similar in relation to interest payments?
My Lord, no.
No.
Now,
So is Mr. Justice Collins' case to the same effect?
it effectively follows what Mr. Justice Lindsay says, my Lord. It's also in Bundle A10 in the next tab. I have rather diverted myself from dealing with the Court of Appeal's approach to this, which is, if I can invite your Lordships just to go back to...
Yeah, of course. Sorry, it's my fault.
No, not at all, my Lord. As a result, I've traversed a fair amount of what I was proposing to say, maybe not in the order I was proposing to say it. Can I then invite your Lordships just to go back to the Court of Appeal, just picking it up at paragraph 42. The question posed in the present case is whether when section 80 sub 7 takes away the right to claim the repayment of the principal sums in restitution, it remains open to the taxpayer to advance a claim in restitution for the interest. Even when the cause of action for the repayment of the principal in restitution is swept away, it remains the case that the tax is wrongly paid, that HMRC were at all material times under a liability to repay it, albeit under section 81, and have been enriched by the retention of the interest. These elements are, as it seems to us, enough to constitute a cause of action in restitution. Whilst therefore we reject HMRC's initial point, the discussion thus far throws some light on the issues of construction of section 78. Now, what follows then is the Court of Appeal identifying a conundrum of the sort that your Lordships have been putting to me. Just read on. All claims for repayment of wrongly paid VAT are claims under section 81 and will normally carry with them a restitutionary claim for interest, including compound interest. Moreover, subject to the section 78 reservation, all claims for interest, at least in case of error on the part of the commissioners, are within section 78 and therefore intended to be subject to the simple interest provision of section 78.3. If the section 78.1 reservation includes restitutionary claims for interest, section 78 would never apply. That is because, given the residual and subordinate nature of the section 78 reservation, it must yield to the common law restitutionary remedy which will always be available. And just pausing there, this is in effect Mr. Justice Voss's nonsense point, in my submission, a consequence of changes in the common law. There are potentially two solutions to this conundrum. One is to construe the section 78.1 reservation so as to exclude common law claims for restitution based on the time value of money. The other is to say that the words used are apparently unqualified and that at the time that Parliament enacted the sections in 1991, it used language which, although it did not appreciate it at the time, was wide enough to include a common law restitutionary claim for the time value of the overpaid tax when that cause of action finally came to be recognised. So that's how the Court of Appeal sees it. Effectively, if you don't go for its option one of treating my client's claim as not a claim for interest, it accepts, in effect, that it will come within the saving words and therefore there will be a common law claim for interest, and indeed that most people will have a common law claim for interest. The Court of Appeal opt for option one, as your Lordship see. The words chosen by Parliament in the section 78.1 reservation are not obviously apt to cover a restitutionary claim for the time value of money. The words are, if and to the extent that they would not be liable to do so apart from the section, they shall pay interest. Thus, the liability must be one to pay interest. It is true that in some circumstances the restitutionary claim will lead to relief for the claimant, intended in general terms to reverse the benefit gained by the unjust enrichment, which may be calculated by reference to interest rates. But it is a strange use of language to describe this as a liability to pay interest. Mr. Rabinovitz responds to this point by saying that if the restitutionary claim is not a liability to pay interest, then Section 78 is not an obstacle to bringing it at all. Section 78 is only an exhaustive code for interest. If the restitution claim is not properly described as interest, then it escapes the clutches of Section 78 altogether. We do not accept that argument. Section 78 can and does form a coherent code for compensating taxpayers for the time value of money. It is inconsistent with the code in the Monroe sense, to allow restitutionary claims for the time value of money. The method of compensation of the taxpayer, which Parliament has chosen, is to require HMRC to pay interest under the section, unless they would be liable to pay interest in the sense in which we understand it under some other provision. That construction gives precedence to other interest regimes, such as the power of the tax tribunal to award interest after successful appeal in Section 84 of the VAT Act, or the court's power to award interest under Section 35A of the Senior Courts Act, but otherwise preserves the operation of Section 78 scheme in other cases. Section 78.1, read as a whole, and in the context of fiscal legislation, makes it clear that the object of the reservation was to ensure all taxpayers in all situations had the same minimum entitlement to interest, not to give taxpayers a springboard for asserting a right to a much more generous nature. My Lords, I have to say, it is difficult to understand what the Court of Appeal was saying, particularly at the end of paragraph 47, but I'll come back to that if I can. Can I, however, deal with its primary reasoning, which is that the claim that Littlewoods brings here is not in fact a claim for interest, and therefore will not fit in the words of reservation, if I can put it there. My Lords, we have a number of responses to this analysis, but I should make it clear right away that we respectfully submit that this distinction between claims for the time value of money and claims for interest is with respect to a distinction without a difference. Moreover, my lords, on any ordinary use of language, a restitution claim for the time value of money does involve a liability to pay. And can I, for this purpose, just ask your lordships to take up the decision of the House of Lords in Sempra. Your lordships will recall A11,
Yes.
tab 88. I'll be going back to Sempra for issue 6. There are one or two passages in it that are also relevant to this issue. And in particular, this distinction that the Court of Appeal sought to draw between claims for the time value of money and claims for interest. Can I ask your lordships to look first at paragraph 1 in the opening words of Lord Hope's speech at page 3596.
Yep.
First words of the decision. My lords, this is a case about the award of interest. Now, that was a case where a claim was brought for the time value of money brought on an unjust enrichment basis. Lord Hope, your lordship sees, characterises as a claim for interest, and he uses the same expressions repeatedly in his speech to describe Sempra's claim. Another example, paragraph 25, page 3604. Between E and F, your lordship C, speaking of a restitutionary award by way of interest. And then just above that, your lordship C, he notes that the unjust enrichment principle supports the freestanding cause of action to recover interest. Paragraph 26H, Lord Hope speaks of the jurisdiction to award compound interest at common law, being a short but logical step in the further development of the restitutionary remedy. That's on the same page, your lordship sees at H. Paragraph 40, 3608. Between G and H, the claim for interest in this case. I'm going to take one more example, my lord, because otherwise I shall weary your lordship with these. 3615 in Lord Nichols, at C.
Sorry, what page?
3615 in the speech of Lord
Yep,
Nichols.
got it. Paragraph.
66.
Paragraph 66.
Thank you.
The essence of the taxpayer's claim is for an amount of money by way of interest in respect of tax paid prematurely. And one can find similar comments in this, similar expressions used in the speeches of all of their lordships, Lord Walker, Lord Scott, and Lord Mans, but I'm not going to take your lordships to it. So certainly, my lords, their lordships in Sempra would not have sought to distinguish a claim of the sort that is being brought here from a liability to pay interest. They plainly regarded this claim as being one for interest. I would also note, my lords, in relation to this point about whether there is this distinction, as the Court of Appeal in paragraph 45 suggested, that the Court of Appeal itself, and indeed HMRC, both refer to Littlewoods' claims as being claims for interest. So far as the Court of Appeal is concerned, can I invite your lordships just to look at paragraph 42 of the Court of Appeal decision. So that's at, if your lordship's in the full bundle, page 32.
Yep.
Bottom page 32.
Paragraph
It's at the end of the
42.
first sentence, paragraph 42.
Yep.
End of the first sentence in the third line.
Yep.
The claim brought is described as a claim for restitution for interest. And it's not just the Court of Appeal, the Revenue also, or the Commissioners also, or HMRC also, do the same. If your lordships go to HMRC's case in Core Bundle 1,
Okay.
paragraph 8, so that's Core Bundle Volume 1, internal page 4, bundle page 158. Lordship look at paragraph 8. The outcome of this litigation is itself a matter of general importance. Littlewoods has judgment for approximately, your lordship fees, 1.25 billion, further 5,000 claims for compound interest in connection with VAT. So they certainly see this claim as one for interest. And that's why, in our respectful submission, my lords.
Well, that was the whole basis on which it went to Europe.
Exactly, that was the next point I was going to make. Europe would be very surprised to know that this was not a claim for interest, and that the Court of Appeal considered that there was this distinction to be drawn. So, my Lords, we respectfully submit that the Court of Appeal, in its primary reasoning, which was this attempt to distinguish our claim from a claim for interest, was with respect wrong. A distinction without a difference. And while your Lordships have the Court of Appeal open, can I go back to paragraph 47?
Yes?
Sorry, before I go back to paragraph 46, your Lordship will see the point that I made there before the Court of Appeal, that if this isn't a claim for interest,
Yes.
then it's difficult to see how my claim could be stopped by Section 78.
You say Section 78 has nothing to do with it, you want to rest
Exactly.
declared.
Even if it's an exhaustive code, and
Understand.
it comes to the question whether it's an exhaustive code, it would be an exhaustive code in respect of interest. If my claim's not for interest, I'm not affected by it.
Yeah.
So if my claim is one for interest, on the Court of Appeal's reasoning, I'm within the reservation. If it's not a claim for interest, then
There's
I don't
nothing
care
to
about
stop you
Section
making it.
78. Beg your pardon, my Lord?
There's nothing to stop you making it.
Exactly that,
Yeah.
my Lord. And then just can I on this point, because your Lordship sees in paragraph 47 where your Lordship has reasons why the Court of Appeal does not accept my submission, that the Court of Appeal referred to Monroe. And it refers to Monroe, just as my learned friends do in their skeleton argument, in support of the proposition. I think my learned friend took you to paragraph 22 of Monroe, and perhaps worth just going back to that. It was in bundle 9, at tab 79. Paragraph 22, your Lordships will find at page 3214. Your Lordships, in my judgment, if your Lordships there, it's Lady Justice Arden, the authorities give clear guidance that if Parliament creates a right which is inconsistent with a right given by the common law, the latter is displaced. By inconsistent, I mean that the statutory remedy has some restriction in it which reflects some policy rule of the statute, which is a cardinal feature of the statute. In those circumstances, the likely implication of the statute, in the absence of a contrary provision, is that the statutory remedy is an exclusive one. Your Lordship sees that Lady Justice Arden and the Court of Appeal come to that after referring to a number of cases, as in paragraph 21 above, including DMG, another case called Total Networks. And in all these cases, my lords, one is dealing with a statutory scheme which has no express indication of whether the statute is intended to be exhaustive. And the point that is being made by the Court of Appeal here, and indeed is drawn from these earlier cases, is that where you have a statutory scheme which is in material respects inconsistent with a common law claim which might otherwise exist, the implication that you draw in the absence of an express provision is that the statutory scheme was intended to be exhaustive. My lords, there are limits to the Monroe application. In the first place, as your lordships will appreciate, if you have a statutory scheme which has an express indication that the statute is intended to be exhaustive, then the Monroe doctrine, if I can call it that, simply has no application. And it has no application because the question for which the Monroe doctrine serves a purpose, i.e., should we be implying a provision which makes this an exhaustive scheme, is otiose, because the scheme has something which expressly says that. And an example of that is Section 80, subparagraph 7, or Section 80. In Section 80, there is a provision which expressly says Section 80 is exhaustive. Another situation in which, in our respectful submission, the Monroe doctrine has no application is where the statute is, by express indication, not intended to be exhaustive. Because if it is expressly not intended to be exhaustive, the court's role is not to try and imply something in it to make it exhaustive. You're being told by the legislature that the statute is not exhaustive. And with respect to my learned friends, and indeed the Court of Appeal, that is precisely the position in relation to Section 78.1. We are told that Section 78.1 is not exhaustive. That is the effect of the words that we've all been looking at. So, my Lord, Neither, in section 78.7, you're told that expressly that it is exhaustive. In section 78.1, you're told expressly that it is not exhaustive.
Well, if you're right, if you're conferring a residual right, how can you claim it's exhaustive?
Precisely that. But that's what the Court of Appeal analysis does, and indeed that's what my learned friends in their analysis do. It cannot be exhaustive. We're told that it's not exhaustive. And so, with respect to the Court of Appeal reasoning in paragraph 47, it just does not make sense in the context of this provision. It doesn't make sense, my lords, in another way. And that is because of the last part of section paragraph 47. Your lordship see this. Section 78.1, read as a whole and in the context of fiscal legislation, makes it clear that the object of the reservation was to ensure all taxpayers in all situations had the same minimum entitlement to interest. Just pausing there, we would respectfully agree with that. It's intended to show that everyone has the same minimum entitlement. But they then carry on with respect to the Court of Appeal.
You say the next bit's a non sequitur.
It doesn't follow. Yeah. There is nothing in the section, or indeed anything that anyone has pointed to, which supports the not to give taxpayers a springboard for asserting a right of a much more generous nature. Whether or not there is a right of a much more generous nature depends on the content of rights which fall within the saving words. As it happens, section 35A gives a much more generous right than section 78.1. The fact that the right that the common law might give is much more generous is with respect to not a reason to preclude or exclude the common law right from coming within those words. There is nothing which supports this limitation. So, my lords, with respect to the Court of Appeal reasoning, I should just read paragraph 48. I don't know if Mr. Elliott was prompting me to do it earlier. The fact that the common law did not recognise restitutionary claims to the time value of overpaid tax when section 78.1 was enacted is not, in our judgment, a factor which helps one to construe that section in the sense contended for by Littlewoods. It is, of course, the case that one cannot narrow the express language of the section 78.1 reservation by references to later changes in the common law. If it were clear that the section 78 reservation included the common law claim for the time value of overpaid tax, then, as Mr. Rabinovitz submits, it would not be legitimate to narrow its scope merely because later developments in the law meant that it would never apply, and we would respectfully, as your lordships would expect, support and accept that. That fact, which we have described as a conundrum above, merely prompts one to ask what Parliament meant when it spoke of HMRC's liability to pay interest in 1991. We think it clear that Parliament did not intend to include within that expression HMRC's liability to compensate the taxpayer in restitution for a claim for the time value of money. So they're back to their primary reason that a claim for a time value of money is not a claim for interest. So we would accept and indeed adopt all parts of paragraph 48 except that last sting in the tail, which depends on reasoning which in my respectful submission cannot be supported. So that's why we respectfully submit that the Court of Appeal were wrong. Just sweeping up, in terms of Mr. Justice Voss and Mr. Justice Henderson, the attempt to draw within those words, what have been called the words of reservation, they're not really words of reservation. They are words which make it clear that the section is residual. But the suggestion that one can, within those words which make it clear that the section is residual, say that they apply only to statutory claims and not to common law claims, is simply not supported by anything in the language of the statute. Nothing that anyone has been able to point to supports that, other than my learned friend's nonsense point, which, as your lordship sees, the Court of Appeal were not impressed by at all. Can I then just sweep up, if I may, by making sure I've dealt with my learned friend's three arguments, because he, as your lordships, as I've already indicated, doesn't matter whether he does or doesn't. He doesn't appear to support the Court of Appeal reasoning, but he has an independent point, which is not the point which found favour with Mr. Justice Voss because he simply draws this distinction in the language between statutory claims and common law claims. My learned friend's point again, his first point, he has 3 points. His first point is section 80 subparagraph 7 means that we don't have a freestanding claim for interest. And in relation to that point, my lords, I've already made the point that if your lordships look at what is said in Sempra, the suggestion that there isn't a freestanding claim for interest just because there isn't a claim for repayment of the overpaid VAT is something which is not supported by Sempra at all. It is inconsistent with Sempra. And your lordship sees the references. I'm not sure I need to go back to those references now. I've dealt with my learned friend's point. His attempt to distinguish Sempra by saying that the claims here, the claim for interest depends upon there having been an overpayment of VAT. With respect, that is true, but it doesn't mean there isn't an independent claim for interest. As your lordship sees from Lord Nichols envisaged that where you have that kind of overpayment, it gives rise to 2 heads of damage. And the fact that one no longer exists doesn't mean the other doesn't exist, and all that it isn't freestanding. They're very clear about that. So that's my learned friend's main point. The second argument that my learned friend makes, and this is between paragraphs 9 and 13 of his written case. If your lordships want to turn that up, it's internal pages 6 to 9 in core volume 1. I'm not going to turn it up myself, but if you want to look at it, it's pages 285 to 288. That involves a slightly different way of relying on section 87. This is not a way which says you don't have a freestanding cause of action. It is a way which effectively says you need to treat section 78 and section 80 as a code which go together. And on that basis, it is said, if your claim for capital is within section 80, so must your claim for interest be within section 80. But with respect to my learned friend, that just doesn't work because it's not supported by how the statute works. We have, in our written case, identified for your lordships a variety of ways in which the sections are different. The first point, and my learned friend says this is an irrelevance, and perhaps he's right, but it exists as a point. The statutes were introduced at different times. So you have the section 80 dealing with overpayment.
Where are we in your case now?
Sorry, my lord, I'll just have it. Core volume tab 10, page 227, I think it is.
Paragraph 51.
Paragraph 51, and perhaps I can just take your lordships through paragraph 51. It would be more efficient than me going around the houses on this. Insofar as Justice Voss's reasoning relied upon an understanding that sections 80 and section 78 were intended in all cases to operate in tandem, and that the sections were to be treated as a single integrated and exhaustive scheme, this was, it is respectfully submitted, not correct. Although they are contained in the same Act and operate in relation to closely related issues, those provisions have independent vitality and are capable of operating separately. For example, interest is payable under Section 78 on underclaimed input tax credits, that's Section 78(1)(b). These are not within the scope of Section 80, but are instead governed by Regulation 29 of the Value-Added Tax Regulations, 1995. Conversely, there does not appear to be any dispute that interest may be payable under another statutory provision on an amount recoverable under Section 80. So we give examples there of a situation in which Section 78 operates where Section 80 doesn't, and there are examples where Section 80 operates and Section 78 doesn't.
But of course, the starting point for Section 78 is an official error. That hasn't seemed to... What was the official... in this case, VAT was paid by Littlewoods because that's what they thought the law was for 30 years.
Well, there was litigation about it, with the revenue insisting that they pay. So there was, in fact, an official...
And is it common ground that this was caused by official error in this case?
So far as matters for your lordships, yes. I don't think it's suggested...
No, it's just I recall,
Indeed,
my time, that this question of when there's an official error
The litigation was towards the end of the period, was it not? Yes.
Indeed.
For many years, it was an unprompted mistake by Littlewoods. But when Littlewoods said, we've made a mistake, the Revenue said, no, you haven't.
Yeah, indeed. And the litigation went on for a very long time. I don't think there is a dispute between the parties that there was, for the purpose of Section 78, an official error.
What, from 73?
Indeed, I think so.
And that this was the cause of it. I mean, I do recall there being some issue about this in the days when I used to do these cases, about the extent to which you paid money through your own, without being prompted by an official error, then you couldn't necessarily have a claim for it. But anyway, that's not an issue in this case.
It's not an issue here. Can I just finish with paragraph 52? Provisions are separate and independent are reinforced by differences in the circumstance in which they're introduced. Section 80 was introduced by the Finance Act 1989 in response to the decision of the House of Lords in Fine Arts Development. It had previously been thought that the taxpayer had no right to repayment of overpaid VAT, but their lordships found that such a right was implicit in the VAT Act 1983. Section 80 was introduced to put that right on a clear statutory footing, and perhaps more importantly, to limit the right by providing HMRC with an unjust enrichment offence. As mentioned, Section 78 was introduced 2 years later. Before then, statutory interest was available only in limited cases, although HMRC believed they had a discretion to pay interest and exercised that discretion in case of departmental error. When the 1991 Finance Bill was discussed in Standing Committee, this clause was presented as a concession to taxpayers rather than as a means of curtailing a right and not preventing, and as not preventing ex gratia payments still being made in appropriate cases. In short, Section 78 was enacted so as to confer additional rights on taxpayers where there might otherwise be none, not to exclude existing rights.
Have we got that Hansard extract?
Your Lordships do have that. A2, tab 24, page 1007. So that is what we say about the second of Malone and Friends' point. And although, as your Lordships would have seen, that was a point that did appeal to Mr. Justice Voss, it wasn't a line of reasoning which attracted itself to the Court of Appeal. The Court of Appeal recognised that Section 78 and Section 80 were distinct provisions, and that for Section 78 claims, because of the words of reservation, the section simply could not be said to be an exhaustive code of claims for interests. Can I just see what else
Yes.
I haven't yet dealt with?
Yes, you can.
Yes, my lords. I should just summarise our position in relation to Malone and Friends' second argument. We say that HMRC are wrong to describe Section 78 and Section 80 as a single integrated regime, and to place so much emphasis on the relationship between the two. They are different provisions aimed at different issues, introduced at different times with different scopes, having dramatically different wording in terms of the issue as to whether the remedy they would provide was intended to be exclusive or not. Now,
Otherwise, it's okay.
otherwise, what he says is fine. Not great, but fine. Now, I ought just to, I think, just conclude on Malone and Friends' third argument, which is the nonsense argument. And I think I've already addressed your Lordships on this. I'm not sure there's anything else I can say. Mr. Justice Voss said is true. Said our submissions make a nonsense of this provision because effectively it makes the provision OTS. That may be so, but that is not a reason, as the Court of Appeal said at paragraph 48, to go and read words into the statute which are not there. That is a consequence of developments in the common law, and that would be your Lordships legislating rather than interpreting. If your Lordship said, well, in light of all of this, we have to find words which exclude this claim, that would be judicial legislation. Your Lordships, I've made the submission before, it didn't work so well last time. I'm hoping for better luck this time. In my respectful submission, this is a different case, and this really would be judicial.
Well, we would say we weren't judicially legislating last time, so we accepted your submission. We just didn't think it applied.
Oh, but on this case, my Lord, your Lordships will see that it does apply. It's because you really would have to change the word.
Understand?
Subject to anything your Lordships want to put to, me to deal with in relation to issue one.
In terms of time, obviously, if we go on to consider the other points, are we doing okay in terms of time? It's a bit difficult to
my
estimate.
Lord, yes. I think I'd allowed myself an hour and a half for this.
So would it be sensible to rise now? Would you like to start on?
I think it would be very sensible to rise
Can,
up.
can I ask you a question which is of significance to me, if to nobody else? Are we going to have a transcript of the argument?
I believe so.
Somebody's been working
Yes, you
rather
are.
hard.
But I had inferred from the
Vain.
fact this lady is here that we
Yes,
are.
and it's
Very
been
much.
confirmed.
Not just here for fun. Very well. We'll resume again at 10:30 tomorrow. Thank you very much, Mr. President.